Everyone else can stretch out. You don't have to sit so close anymore. Okay, if you can fix your attention to the screen, I have some instructions. Ladies and gentlemen, I am Judge Kristen D. Simmons, and it is my pleasure and privilege to welcome you to the 54A District Court of Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution have a right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that may influence you for or against the prosecution, defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask each of you to stand and swear truthfully, fully, and honestly to answer all questions that will be asked about your qualifications to serve as a juror in this case. If you have a religious belief against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. All jurors can rise. Raise your right hand. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? If you do so, please say I do.
I do.
Thank you. You can be seated. I will introduce my staff to you. To my right is my court reporter and judicial assistant. Her name is Miss Addie Nash. And then seated right there in the green is my court officer. That's Ms. Yolanda Collins Green, and she's assisted by court officer David Warnsley today. This is a criminal case involving the charge of prohibited noises generally, animals and birds, which I will explain more fully later. This charge has been made against the defendant, who is Mr. Frank Lee Cole. The defendant's attorney is Ms. Taylor Wicks. Ms. Wicks, if you could stand, please list any witnesses you anticipate calling in trial today.
The only witness defense may call would be Mr.
Okay, and the city attorney is the prosecutor in this matter. We have, I think, first chairing is the Assistant City Attorney, Ms. Amani Williams, and she's second chaired by the Deputy City Attorney. Please stand, introduce yourself, and list any witnesses you may be calling.
Morning, everybody. My name is Amanda O'Boyle, and witnesses that may be called in this case are Officer Tyler Stover, Officer Jacqueline Lindeman, and citizen Tammy Olson.
And does anyone in the jury box or anyone in the gallery recognize those names, know any of the defendants or any lawyers or witnesses that were named? If you do, just raise your hand. Okay, you know someone?
Just Amanda.
Oh, you do know, you know her personally?
No, I worked at the city in the mayor's office.
Oh, your name did seem familiar. Okay, let's see. Anybody else know anybody? Okay. Any objection to me removing Ms. Sean
Marchand, yeah.
Marchand from the jury for cause? Okay, you may be excused. Thank you for your service today. I'm gonna replace that with seat number 7 is gonna be Jason Tubbs. Okay. And the new juror number 7, you did not raise your hand. You don't know anyone listed?
No,
Okay.
I do not.
Very good. We think that this trial will last for one day. That doesn't mean all day, just we won't be expecting you to come back tomorrow, but it's a possibility. If you believe that the length of trial will be a real hardship for you, please raise your hand so that I can know that this will be a hardship for you. Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical condition or problem that makes you unable to sit for 2 or 3 hours at a time? If you do, you'd raise your hand. Does anyone have a sight or hearing problem? Can everyone hear me clearly?
Yeah.
If you can't hear me, raise your hand. No, if you can hear me, raise your hand. Okay, that's everybody. Okay, everyone can see clearly. It's a small courtroom, so if there was any visual aids, they won't be too far. And then we won't sit for longer than 2 hours. You don't have to have a medical condition not to be able to sit for 2 hours. That's too long. We can get up and stretch in between there. This is a criminal case. The paper used to charge a defendant with a crime is called a complaint. And the complaint in this case charges the defendant as follows. On or about October 2nd, 2023, the complaining witness states at the date and location above that the defendant did allegedly own, possess, or harbor any bird or other animal, to wit dogs, which frequently or for continued duration makes sounds which create a noise disturbance across a residential real property boundary or within a noise sensitive zone at the area of 304 Denver Street, and that this is contrary to the provisions of the Code of Lansing, being 654.07D. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal case so that the defendant and jury can hear the charges. You must not think that it is evidence of that he is guilty or that he must be guilty because he has been charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. We will now begin with our voir dire.
Morning, everyone. My name is Imani Williams. I'm just going to ask you a few questions. Ever make a noise complaint? Neighbor, roommate?
No.
Have you ever been the subject of a noise complaint? Someone complained about you for being loud and noisy? Do you think it's acceptable to call the police if there's a noise complaint? Why is that?
There's a statute being more violated, then there should be consequences.
I agree. So do you believe that a barking dog is a crime? What if I tell you some more? What if I give you some more information? Do you think that a dog barking day and night, non-stop, at all hours of the day, all hours of the night, would you agree that this is a crime? Do you believe that dogs barking can be annoying, can be considered a disturbance?
Yes.
Have you ever had any interaction with the police in general?
Yeah.
Yes. Would someone care to elaborate on that?
I had my vehicle stolen a couple years ago.
For the record, this juror number 7.
How was your interaction with the police?
Fairly okay. Not very helpful, but they were fairly nice about it.
And what was the outcome of that interaction?
Ended up getting the vehicle back in the end, thankfully. So.
Anyone else want to tell me about your interaction with police department? Yes, it does. How did you find that?
Oh, it was all right, yeah. It's gonna give me
For the record, that's juror number 6.
Anyone else?
Yes, I've had multiple traffic stops. So call the police when I travel in danger. Also had my spouse call the police and interacted with them when they were called to my residence multiple times on safety checks. I've also interacted with the police when my child was missing.
And that's-
I
need-
apologize.
For the record, you gotta tell us what juror it is.
Okay.
That's juror number 3.
And how was your interaction with police? Were they helpful? They were helpful. So do you think if I prove all the elements of the crime beyond reasonable doubt, would you be able to, is it going to be easy for you to find the defendant guilty, or is it going to be hard for you to find him guilty? I will repeat the question. So the judge gave us the elements of the crime that the prosecutor has to prove to you beyond reasonable doubt. So if I present the facts and the witnesses that prove the element of the crime beyond reasonable doubt, would you be able to find the defendant guilty, or do you think it's hard for you to do that? Why that?
Just finding.
Thank you, John. Anyone else?
Any additional voir dire for the city for now? Are you still voir dire?
I think, yes, Your
Okay.
Honor. Number 4. When Ms. Williams had inquired earlier about, do you think a barking dog to be a violation of the law? I believe I saw you say no. Can you tell me a little bit about what makes you have that perception? or point of view?
So I guess I do understand like the Wisconsin and this disturbing, I guess. It's just, I don't know. I guess if authorities did come in and report a few times, then I would think that they would take action. But I don't know, it depends on, I guess, if there's a lack of action, maybe.
What do you mean by action?
If you're disturbing somebody and that person doesn't know that they're disturbing you, you cannot be aware of their surroundings.
Oh, I see. Okay, so you would want somebody to have told that person, your dog is disturbing others, and can you do something about it? You would want that interaction to have happened before a criminal charge would be brought.
Yeah, right.
Okay. You're number 5. I believe you had also said that you didn't think barking dogs were a crime. What's kind of your perspective?
With any disturbance, I think you have to address it yourself. Before going to police, and I mean, yes, it could be annoying, but I don't really feel a dog barking at the time.
So you think it's a matter that is best resolved between neighbors?
Yes, it does.
Okay. If in your endeavor to try to resolve a neighbor dispute, if you're not successful, what would you believe the right course of action would be?
If I'm not successful after a few times, yes, I would try to get some help.
Who would you call for help? So you think at a certain point in time, it is appropriate to call police and have them intervene in a situation. Now, are any of you guys pet owners?
Yes.
Okay, what sort of pet do you own? Cats. Cats, okay. Are they outdoor cats, indoor cats? Indoor cats. Indoor cats, so they're not out there causing too much crime, are they? No.
They cause crime.
Of course, of a different malicious nature, certainly. Have you ever had a neighbor with pets? And has that ever been a problem in the past for you?
I've had neighbors with dog dogs, but I don't.
And in those circumstances, you just live with it. How did you handle that?
I just.
Understood. But do you think you'd be within your right to call police if it got to a certain point that you couldn't handle it anymore?
Possibly, yes.
You're number 2. You said that you have pets?
Yeah, I have a dog.
You have a dog? What kind of dog?
She's a mutt.
Yeah, a lovable mutt.
Yeah.
Does she bark sometimes?
She barks sometimes,
Okay,
and then I go and see what the problem is.
okay, so you take,
Right.
advocate and go and take care of the situation when you hear your dog barking. Do you think it's a dog owner's responsibility to go out and if you hear your dog barking, go address the situation?
I think so.
Okay. Have you ever had a neighbor talk to you about your dog's barking before?
No,
Because you're really great at taking care of your dog.
or they see that I try, and make
Sure.
an attempt.
Sure. You're number 3. I think you also said you
No
had
pets.
no pets. Okay. Have you ever had a pet?
Yes.
What have you had in the past?
Goldfish, lizard, and dog.
Okay. The dog that you have had in the past, did you ever have any issues with that dog barking before?
Yes.
Okay,
But as a child.
okay. Have you ever had any neighbors with dogs or anything like this?
No close.
No close neighbors? Okay. For number 4, do you have any pets?
Right now, it's a cat, I did, younger, have like a family dog.
Family dog, okay. Were there ever any instances where your dog would bark? No, okay. Well, that's a situation in and of itself, though, right? Because sometimes dogs can jump on people they don't know. Did you ever encounter that?
Yeah.
And how did people sometimes respond negatively to that jumping? Not too much. Okay.
I mean, yes, I guess my, said that down, but other than that,
But generally, you guys took care of your dog, made sure that no trouble, no
Yeah.
instances, those sort of things, right? Have you ever had a dog or a pet?
Yeah.
What sort of pet?
Should be right now.
Come on.
Thank you and excuse juror number 6 for your service. Okay, and I'm going to replace seat number 6. But first, let me see if there's any challenges for pre-emptories from the city.
None, Your Honor. And from defense, thank you.
Okay, and so number 6 will be Brian Whedon. Okay, you can question juror number 6.
Okay.
Hi.
You have the questions that we asked earlier.
Yes.
Do you have a noisy neighbor at the moment? Or have you had a noisy neighbor in the past?
Not at the moment, but I have.
Can you tell me some more?
I did have a neighbor that had some dogs that used to bark late at night and actually honestly made the situation worse by yelling at them at one point.
What did you do about that?
To be honest, it wasn't that big of a noise, so we didn't do anything about it. I didn't know that neighbor at all.
So you didn't try to talk to him, you didn't pursue this further?
No.
But do you think the dogs were barking day and night at all times? You can't open your windows because you will hear them. What would you have done hypothetically?
I think I would start by talking to the neighbor about it.
And what if you don't get a response from them? What would you do?
And at some point, I could see a time where you call the police.
Have you ever had any interaction with law enforcement?
Sure.
Can you tell me some more?
Typical traffic stop stuff. One incident a long time ago where I was accused of looting someone for a minute, but that got, like I never heard from it again after the knock on the door and interaction with the police officer.
And how was your interaction?
See, that one was bizarre, but other than that, it was fine.
Okay. And do you own a pet right now? Have you owned pets? in the
I have
past?
owned the pets in the past, and I have any right now.
What did you have in the past?
So we've had a bunch of pets, and I was thinking about this because of the questioning. I don't think any of them are noisy, actually. We've had fish and cats and horses.
You haven't had dogs?
I haven't had dogs.
Thank you.
Swix.
Juror number 6, you a sports fan?
Yeah,
Okay, so let's think of it this way. There's a challenge on the play. Pull the red flag out. You're a football fan, I guess, before we go with this one.
yes.
Okay, so the challenge flag is on the play. This is now your decision. The refs have called something on the field. It's now up to you to make the decision in this case. Are you going to, just because that's the way the refs called it on the field, are you going to agree with them?
Well, no.
What would you like to see to change your mind? You can go outside the sports metaphor here, but what's something that would change your mind?
I'm struggling with the metaphor a little bit because in football, it's actually the ruling on the field stands unless you find conclusive evidence to refer it. But in court, it's more or less the opposite, right? So it's not really the same.
See, you got it all on your, I was going to explain at the end, once you kind of explained the football rules to everyone, I was going to flip that on its head and show how it works, but thank you, you got ahead of that for me. So as, again, taking personal accountability for maybe an action you didn't take, have you ever experienced that?
Like being held accountable for something you didn't do.
Yeah, that if somebody, that it was easier kind of for you to take responsibility than, or, my kid did something, I'll just, hey, my bad, we'll fix it. Or maybe at work that, a team project maybe went sideways and you're like, hey, guys, I got the blame on this one. Anything like that?
I can't really think of anything.
Okay. Do you have a security system in your house?
I do.
You haven't had any problems that you've perceived in your neighborhood to try to get one, or think one was necessary?
Not really.
And thank you.
Thank you. Any challenges for cause?
No, Your Honor.
No, Your Honor.
Any preemptory?
No.
None from defense.
Satisfied with this panel as set?
Yes, sir.
Yes, Your Honor.
You, ladies and gentlemen, we have a panel of jury, and for those of you all who anxiously waited a turn to potentially be a jury or juror in this trial, I apologize that you won't get an opportunity today. There are, I'm sure, the potential of jury opportunities tomorrow. So I'm going to relinquish the remaining of you into the custody and care of the court administrator for further instructions. All rise for the jury. Okay, thank you. And the remaining of you can be seated. Very good. Okay, I'm gonna have you turn your attention back to the screen for some additional instructions. We'll do that and then we'll take a break so you all can have your lunch before we get into the opening statements. Okay, ladies and gentlemen of the jury, you have been chosen to decide a criminal case made by the city of Lansing against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try this case justly and to reach a true verdict. If you have religious beliefs that do not permit you to take an oath, you may instead affirm to try the case justly and to reach a true verdict. If the jury could please stand and raise your right hand. Each of you solemnly swear or affirm in this action now before the court, you will justly decide the question submitted to you, that unless you are discharged from the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instruction of the court. If you do so, please say I do.
I do.
Thank you. You can be seated. You will get a written copy of my instructions, but you won't get them until the end of the trial when it's time for you to deliberate. Since no one can predict the course of a trial, these instructions may change at the end of the trial. Now I will explain some of the legal principles you will need to know and the procedure we will follow in this trial. First, this is the city ordinance that is being charged. It's prohibited noises, generally animals and birds. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant did own, possess, or harbor a bird or other animal, to wit, a dog, and that means meaning a dog, that the animal frequently or for a continued duration made sounds, and that the sounds created a noise disturbance across a residential real property boundary in the city of Lansing. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where she gives her theories about the case. The defendant's lawyers does not have to make an opening statement, but she may make an opening statement after the prosecutor makes hers, or she may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents her evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyers has a right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of her evidence, the defendant's attorney may also offer evidence but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyers will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of the case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's race, national origin or ethnicity, gender identity or sexual orientation, or religion, age, or socioeconomic status. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to make an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my own opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to the court staff, who will give it to me. Do not show your question to the other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater testimony or greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. Excuse me. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and that you are not allowed to discuss the case. If they continue, leave and report the incident to court staff as soon as you return to court. When the trial is over, these restrictions no longer apply, and when the trial is over, you may, if you wish, discuss the case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth and lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider must meet certain standards. Again, for example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These instructions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to research or search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see we have chosen a jury of 7 after you have heard all the evidence and my instructions. We will draw names to pick one to be dismissed to form a jury of 6. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You must consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. This means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. And that concludes our procedural instructions. It is 12:09. I'm going to give you break for lunch. And you should be back at 1 o'clock. There are a few restaurants down on the main strip there. Again, remember the jury instruction, like you have to be careful and not to have any communication with anyone connected to this case. You don't know who's connected to this case, so you should be cautious about speaking to anyone. If anyone violates that rule, or it's discussing the case in your presence, you need to report it as soon as you get back. You also have your juror stickers. You need to wear those on you so that people around you know that you're a juror, and that way they won't inadvertently violate any of those rules while you're traversing in the hallways. And we will have that back room here, the jury room, open for you. You can leave your bags in there. That room will be locked, and the only individuals allowed in there is the jury. So we'll see you back here at 1 o'clock. All rise for the jury.